My name is Paul Taske, and I'm the Associate Director of Litigation at NetChoice. We sued California for a third time. This law places new and unjustified burdens on marketplaces when Congress has already said that the states cannot act here. Congress passed the Federal Inform Act in 2023, and California is going directly against the will of Congress. This law impacts California businesses by placing regulations and restrictions on online marketplaces in California. So think about OfferUp or Craigslist or Facebook marketplaces, places where people can go to offer goods for exchange online, and then they can meet up in person to complete the transaction. That's what is regulated here. And the law places burdens that tell the marketplaces that you have to go now and track all of the transactions that happen off your website, but that were initially started on your website. It's not clear if it's even possible for websites to be able to do that kind of tracking. It places an unjustified burden on the marketplaces and discourages them from even offering these services. Law enforcement, in order to prosecute digital criminals, retail crime, and other bad actors, has to have evidence necessary to bring a case to court and sufficient evidence to convict those criminals. This law, by requiring websites to monitor and then turn over any evidence that they discover, would actually undermine law enforcement's ability to use that evidence in court. The Fourth Amendment prevents the government from compelling people to provide information to the government. And by compelling this sort of provision, it means that the government is going to be hamstrung. They are hamstringing themselves, they're hamstringing law enforcement, and they're hamstringing the businesses who could legitimately suffer from retail crime and retail theft. Because this evidence would be unlawfully obtained by the government, it would be inadmissible in a court of law. Websites regularly report bad actors online. They make these voluntary efforts, and that evidence can be used in court. But when the government is compelling evidence collection by third parties, then that is when that evidence could not be used in court. So it means that government can't go after the bad actors as effectively, but by encouraging websites to voluntarily continue taking the good actions that they do to report these things voluntarily, that evidence would be usable in court and is regularly reported by businesses already. California's law is written really broadly, and that has some major unintended consequences to the point where you might think that it's ridiculous that it would have this effect, but it's the way the law is written. For example, if a local Girl Scout is posting on Nextdoor saying that they are selling cookies for their annual cookie sales and are encouraging people in their neighborhood to come and sign up for buying the box of cookies that you would normally buy. For me, it's Thin Mints. That could be captured by this California law. It would discourage websites like Nextdoor or Facebook Marketplace from allowing people to post these sorts of advertisements for new products on their services. And if it's capturing Girl Scouts, there's no telling what else it could capture. In 2023, Congress passed the Federal Inform Act for preventing this sort of patchwork application of state regulation. California can't now go in and say, we're going to second guess Congress. California's law imposes new burdens on websites, it imposes new burdens on marketplaces, and it discourages websites from being able to offer these valuable and crucial services for Californians. And so we are suing the state of California to stop this law from going into effect and to preserve our system of government, which says when Congress speaks, its law must be followed over conflicting state laws.